The US privacy landscape is on the edge of a new era. The California Privacy Rights Act leads a wave of 5 state-level privacy laws taking effect in 2023 that will remake the terrain for the advertising industry. All right, that all sounds pretty dramatic, so let's take a step back from the cliff and talk about what's going on.
Next year, companies ranging from brands and publishers to agencies and ad tech firms will need to comply with new privacy laws in Colorado, Connecticut, Utah, Virginia, and of course, California, where the existing California Consumer Privacy Act will give way to the more comprehensive California Privacy Rights Act, or CPRA. One thing I've been wondering about CPRA is whether it taking effect will simplify the US privacy picture or complicate it. And in November on the Digiday podcast, I put that question to Sarah Bruno, who is a partner at the law firm Reed Smith.
Oh my gosh, I love that question. It's getting so complicated. It's gotten very complicated as a result of CPRA.
Sarah was far from the only privacy expert I've talked to who said that CPRA is upping the ante for companies in the advertising industry to comply with privacy regulation.
CPRA definitely raises the bar. It I think the changes with CPRA were to be able to address some of the areas that was the considered in the original intention of CCPA, but in the actual fine points of the language and the law, the interpretations that came out of that didn't necessarily address what was intended when the CCPA was put into place, which was a broader layer of restriction on the kind of use cases, probably under the digital advertising umbrella.
So, what is it about the CPRA that raises the bar not just on California's pre existing privacy law, but on the US legal privacy landscape in general? Well, there are a whole host of changes in the CPRA, but here are the big ones when it comes to advertising. The CPRA requires companies to let people opt out of their data being shared for cross contextual behavioral advertising purposes. It introduces a new category of sensitive personal information that includes precise geolocation information. And it removes the 30-day grace period for companies to address any violations before being fined. Probably the biggest change for companies in the advertising industry is that new right for people to opt out of their data being shared for cross contextual behavioral advertising purposes. A big gray area of California's pre existing privacy law has been its definition of sale. The CCPA required companies to notify people if a company sold people's personal information and to give people the option to opt out of those sales. The CCPA defined a sale as exchanging data for money or other valuable consideration, which seemed to apply to sharing data to target ads across the internet, but some companies took the stance that they weren't actually selling data when doing that. Sephora was one of those companies and received a $1.2 million fine in 2022 for violating the law.
The example of this is in the Sephora action. Sephora took a very technical reading of we're not selling data because we're not taking data and just receiving monetary consideration for it. We're giving data or we're getting data, but we're not actually paying for that. We're paying for something else. And I think the spirit of what sale was intended to be was probably intended to capture that. And you see that with how the California Attorney General interpreted it in that.
This is a copy of the complaint that California's Attorney General Rob Bonta filed against Sephora, and in it, he helps to clarify how the definition of sale applies to advertising. He writes, both the trade of personal information for analytics and the trade of personal information for an advertising option constituted sales under the CCPA. The CPRA further clarifies this confusion with the addition of sharing and specifically calling out cross contextual behavioral advertising, whether or not for monetary or other valuable consideration, including transactions between a business and a third party for cross context behavioral advertising for the benefit of a business in which no money is exchanged. Basically, if a company is sharing data with other companies in order to target people with ads across the web, mobile, connected TV, or to track how those ads are performing, whether they led people to purchase a product, now has to let people know that it's doing that and give them the option to opt out of that personal information being shared. Now, try to think of a company that isn't doing that in the age of third party cookies and tracking pixels and audience graphs built on people's email and IP addresses.
If a company is sharing cookie data in order to track users or enabling others, sharing information with vendors to track users across multiple websites that are not owned by the advertiser, that's when the, alarm bells go off.
Now consider how interconnected the advertising industry is with cookie syncing and conversion tracking and data clean rooms. That makes the clarified definition of sale and the CPRA's coverage of data sharing pretty consequential. Basically, companies are going to have a lot more contracts in place to control how other companies can use their data.
Contractually, you're going to have to do a lot of contractual work to make sure that your role with your data provider and your data partners is spelled out pretty clearly, and that it accurately represents actually what the data flow is and where you sit in relation to each other.
And as if that's not complicated enough, there's the added complexity of those other 4 state privacy laws taking effect next year. Companies won't be able to just copy and paste their CPRA contracts.
Just complying with CPRA is not going to get you there with Colorado and Virginia. Colorado and Virginia have different opt-ins and opt-outs. They have clear requirements for DPIAs, data processing impact assessments.
I do think that probably the most stringent approach is California compared to the other states because of its opt-out of sale and share. Having said that, there are some sensitive data categories in other of the states that require prior opt-in, whereas California is an opt-out for sensitive data as well.
Enter the Interactive Advertising Bureau's multi-state privacy agreement.
The MSPA is an industry contractual framework that's intended to aid the entire ecosystem, whether it's advertisers, their agencies, publishers, or ad tech intermediaries, in complying with all of the 5 state laws.
The MSPA works in tandem with another privacy framework, IAB Tech Lab's global privacy platform, to provide a means for companies to pass compliance signals through the advertising ecosystem. As you might expect from tools trying to thread the needle through multiple privacy laws, things can get complicated pretty quickly. And I'll do a whole other video on the MSPA and global privacy platform in January. But for now, let's just go with a pretty simple rundown of how this works. Think of the MSPA as like a checklist that companies fill out when they collect someone's personal information and may sell or share that information with other companies. They'll jot down the person's state of residence to signal which privacy laws apply, or they'll label them a national consumer, which means the company is going to try to comply with all of the different state privacy laws and take the most conservative approach. Then they'll provide the different compliance signals. Did the company notify this person of their options to opt out? Did the person opt out? And then finally, the company will signal whether they are operating in service provider mode or opt out option mode. These are the 2 big signals being passed through the MSPA. A big difference between service provider mode and opt-out option mode is that only in opt-out option mode can the person's data be used for cross-contextual behavioral advertising purposes, but even then, companies will need to check that person's opt-out status. Once the checklist is filled out, it gets passed to other companies through the global privacy platform, and receiving the checklist effectively triggers the creation of a contract between the company that originally collected the information and the company now receiving it.
You now need to have a contract, and you don't even have necessarily a direct relationship with that company. So what the MSPA does is it fills the gaps in the digital supply chain.
Cool. So that solves everything, right? No, not at all. I mean, there was that other framework that other organization with IAB in its name put forth to help advertising companies comply with that other privacy law, and that didn't go so great. Actually, in another Digiday podcast episode, this one recorded and released in December, I asked IAB CEO David Cohen if the trade organization had gotten regulators to give their blessing to the MSPA. And here's what he said.
It has been created in consultation with the industry, including the regulators. I can't speak on behalf of them, but we're obviously intending on bringing something to the market that gives all indications that will be satisfactory to all the regulatory bodies.
Interpret that how you will. It seems like a no. But that's also kind of the thing. There's the law, and then there's people's interpretation of the law. And one interpretation that everyone's still waiting on is that of the California Privacy Protection Agency, which is the agency charged with enforcing the CPRA, but that isn't expected to finalize its rules for that enforcement until after the CPRA takes effect on January 1st.
I've heard rumors early 2023. I mean, it'd be great if we got clarity on some of this stuff sooner. The regulations seem to be close to final. So, at this point, we're just left with what the text in the act, which, as I said, isn't super clear.
One thing that does seem clear, though, is that companies can't exactly slow roll their compliance efforts or count on regulators taking a lackadaisical approach to enforcing the law, as if Sephora was an example enough.
While enforcement can't happen for CPRA until July 1st, 2023, the many of the AG's interpretations around things like global choice, cookies, and so forth align with what we're hearing, and how CPRA's regs and the CPRA statute has been articulated and how the regs are fleshing it out. So it'll be interesting to see. I don't see enforcement really abating.
The fact that they went after Sephora, I mean, they're a name, right? If you buy cosmetics, you know them, but I don't think of them as a big player in the tech industry, of course. And so that to me signals that the AG isn't just looking at the household and usual suspects for enforcement. Everybody should be on notice that the AG is looking at them.
Okay, so the horizon for privacy compliance in the US is looking a little stormy, but let's end 2022 with some sunshine. Companies can take solace in knowing that what's required of them to comply with all these different privacy laws is really somewhat simple.
I would really look at that Sephora case. Get those global privacy controls in place on your site. If you're an advertiser, think of yourself as a publisher. You've got a website or, a digital property. Really make sure that you've got the consumer facing controls in place to make sure the consumers have those disclosures and notices to help them understand what their rights are and be prepared to honor those rights